My grandfather built this private lake more than 40 years ago, long before luxury homes surrounded its shoreline. When he passed the property to me, he reminded me that the dam, marina, and water rights carried responsibilities that most people would never understand. I took that promise seriously every single day. One spring, powerful storms swept across the lake for 3 straight days. Heavy rain damaged the shoreline, weakened part of the private dam, and scattered debris across the marina. I knew delaying repairs could put every waterfront property at risk. I immediately hired a licensed engineering company to inspect the structure. Their report confirmed that emergency repairs should begin before the next major storm. Waiting would only increase the damage and cost. Over the next 2 weeks, repair crews stabilized the dam, reinforced the shoreline, and cleared the marina entrance. When the final invoice arrived, the total came to $22,000. Every dollar had protected the entire lake community. Because the HOA residents depended on the lake every day, I prepared a detailed reimbursement request. I included engineering reports, contractor invoices, photographs, and maintenance records. My goal was cooperation, not conflict. At the next HOA board meeting, I calmly explained how the repairs protected every dock, shoreline, and waterfront home. Several homeowners nodded as I presented the evidence. Then the board president asked for a vote. The vote lasted less than 2 minutes. The board rejected my reimbursement request without offering any alternative solution. Linda simply said the repairs were my responsibility because I owned the dam. I reminded everyone that without the dam, there would be no stable lake for boating, fishing, or lakefront living. The room became noticeably quieter. Even those who disagreed understood the importance of the structure. After the meeting, several residents privately thanked me for completing the repairs so quickly. They admitted they appreciated the safer lake, but felt uncomfortable challenging the board's decision. Their honesty stayed with me. The following morning, I met with my property attorney to review every deed, easement, and water rights agreement connected to the lake. We wanted to understand every legal option before taking another step. Facts would guide every decision. The records revealed something most residents had forgotten. My family still controlled the lake's water management rights through recorded legal agreements. Those documents had remained unchanged for decades. Before making any decision, I asked both my attorney and the county records office to verify every document. Each review reached the same conclusion. The Water Control Authority remained legally attached to my property. We sent the HOA one final certified letter inviting them to discuss a fair contribution toward the repairs. I hoped a simple conversation could resolve the issue without further conflict. The decision was entirely theirs. A week later, the HOA's response arrived. The board again refused to contribute anything toward the $22,000 repair bill and insisted the matter was closed. There wasn't a single invitation to negotiate. After carefully reviewing my legal rights, I notified the HOA that I would begin operating the privately owned water control system according to the recorded agreements. Within days, the lake level was temporarily lowered for scheduled management, leaving many private docks unusable until the legal dispute could be addressed. The quiet lake community suddenly realized the disagreement had entered an entirely new chapter. By the next weekend, homeowners walked down to their docks expecting another day on the water. Instead, many boats rested several feet above the lower lake level. An official notice explained that temporary water management was being conducted under the property's recorded operating rights. Linda Harrison arrived shortly afterward with several board members. She demanded that I immediately restore the lake to its previous level, arguing that residents had paid HOA dues for years. I calmly explained that HOA dues did not transfer privately recorded water management rights. Many homeowners gathered around the posted legal notice and carefully read the recorded water rights agreement. Several admitted they had always assumed the HOA controlled the lake itself. For the first time, questions began shifting toward the board instead of me. That afternoon, my attorney received formal notice that the HOA intended to file a lawsuit. They claimed lowering the lake had reduced residents' enjoyment of their properties and requested emergency court intervention. We had anticipated the filing and were fully prepared. Within days, the unusual dispute attracted statewide attention. Television crews interviewed residents, while drones captured images of the lowered lake and idle boat docks. Reporters described it as one of the most unusual property rights cases in recent memory. The judge scheduled an expedited hearing to determine whether temporary water operations should continue while the lawsuit proceeded. Both legal teams prepared engineering reports, property deeds, water rights agreements, and maintenance records. Every document would soon be examined in court. Inside the courtroom, my attorney presented the original property deeds along with decades-old agreements granting my family operational authority over the dam and lake level. Historic records confirmed those rights had never been transferred. The courtroom remained silent as each document appeared on the screen. The HOA argued that generations of community use had created an expectation that the lake would always remain at a recreational level. My attorney responded that expectations could not replace written property rights. The judge carefully noted the distinction. An independent civil engineer testified that lowering the water level temporarily reduced stress on the repaired dam while allowing additional inspections. He explained that the procedure followed accepted engineering practices and protected the long-term safety of the lake. The repair invoices, inspection reports, and contractor records confirmed that the $22,000 emergency work had directly protected the shoreline, marina, and surrounding waterfront properties. Every expense matched the engineer's recommendations. No evidence suggested unnecessary or excessive costs. During discovery, archived HOA newsletters revealed that earlier board members had acknowledged